Okay, good morning. We are here on case number D532026, Don versus Mitchell. Counsel, please state your names and bar numbers for the record.
Your Honor, Anita Webster, bar number 1221. Plaintiff is also present with me.
Don Procopius appearing on behalf of the defendant, bar number 6460, and Jillian Tyndall, co-counsel with me at counsel table.
7194.
Okay.
And my client's here too.
I've heard a rumor
We're resolved.
that you have it resolved.
Yes.
Okay, let's go ahead and swear in the parties.
And,
Did you need CPS
And
too?
before I say, and I appreciate you guys coming, before we go any further, do the parties agree that our representatives from the Department of Child and Family Services may leave?
Yes.
Your Honor.
And do the other stuff that they have to do?
Yes.
Okay.
Thank you.
Thank you.
Stand up.
Go ahead and stand up. Yeah.
Please raise your right hands. You and each of you do solemnly swear that the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth. So help you God.
I do.
I do.
Thank you. Please be seated.
And Your Honor, I'll go ahead and recite
Yeah.
the agreement, if that's okay, and then Mr. Procopius can either agree or disagree with me.
But speak up, please.
Okay.
This room seems to dull sound a little bit, and so I'm always asking people to speak up.
All right. Your Honor, we had previously discussed the fact that the court has complete jurisdiction over the parties. The minor child in this case is Hannah Murray. Reuben Don, born January 20th, 2015, age 2. The parties were never married. We previously had the parties acknowledge the parentage of the child. Plaintiff is the mother. The defendant is the mother. Plaintiff is the natural father. And the minor child, Your Honor, has jurisdiction, the minor child having lived in Clark County, Nevada for in excess of 6 months. We've agreed on the joint legal standard language. My standard language says that if either party are going to leave or have the child away from their home for more than 24 hours, they'll provide a travel itinerary. Mr. Procopius and I did agree on that. The parties are going to share joint legal, joint physical custody of the minor child. Plaintiff's custodial timeshare with the minor child will be each Sunday at 7 p.m. to Thursday at 7 p.m. The defendant's custodial timeshare with the child will be Thursday at 7 p.m. to Sunday at 7 p.m. It's the party's intention that they have an equal amount of days per year with the minor child based upon plaintiff's participation in out-of-state bridge tournaments for 6 hours or more, if he's going to be out-of-state. Plaintiff is going to participate in out-of-state bridge tournaments 7 times a year or more. When plaintiff participates in out-of-state bridge tournaments, which will require him to be gone for 6 hours or more out-of-state, defendant has a right of first refusal. Either party also has a right of first refusal to have the minor child should either party be unavailable for 6 hours or more. And the right of first refusal will not count against either party in a subsequent motion for a change of custody. Should the plaintiff no longer participate in out-of-state bridge tournaments, the parties will change the custodial timeshare so that each party has an equal amount of custodial days. The parties will attempt to agree or participate in mediation prior to the filing of a motion. Either party can use a proxy that's known to the other party to pick up the minor child from the other party, and that proxy can watch the child for up to 6 hours thereafter. That should either party be more than 30 minutes late to a child custody exchange, they forfeit their custodial timeshare until the following day at 7 p.m. The parties shall exchange the minor child at a target between their respective residences. The parties may have witnesses accompanying them to the exchanges. The parties and their witnesses, if any, will act in a businesslike manner and not make comments during the exchanges beyond exchanging pleasantries. The parties may videotape the exchanges. When the minor child attends daycare, kindergarten, or school, the parties will exchange the child at the daycare, kindergarten, or school that the minor child attends by 5 p.m. That within 60 days, the parties are going to switch from talking parents to our family wizard, with each party paying 50% of the cost. The parties will communicate in a businesslike manner without gratuitous comments involving the parties' relationship and or past without unsolicited instructions regarding the minor child and or criticism of the other party's parenting. Unless the minor child is ill, the parties need only communicate once a day at the end of the day to recap the minor child's activities and diet that day. It's further stipulated and agreed that the parties will provide each other an itinerary. Either party will leave the state of residency with the minor child without providing the other party a full itinerary 72 hours in advance, including the inclusive dates and times of travel and the addresses and telephone numbers where the child will be primarily. If the child is leaving by plane, a plane itinerary will be provided. For out-of-country travel, if either party wants to take the child out of country, that party must obtain written permission from the other parent at least 30 days prior to the planned departure date. In addition, if permission is given, the traveling parent must provide the other party a full itinerary at least 2 weeks in advance with the address, telephone number where the child will be primarily, and a plane itinerary again if there's a plane. In the event of an emergency or unforeseen circumstances that could affect an exchange of the child or the time of the exchange, a party can call or contact the other party as soon as possible. The plaintiff will continue to pay the $5.95 per month based upon Wright v. Osborne. Defendant will find employment of not less than 20 hours per week, no later than May 1st, 2017. Upon defendant finding employment, the defendant will, within 10 days of finding employment, notify the plaintiff and provide proof of income. And this will be a continuing responsibility, so that if she loses a job that she gets as of May 1st, she will then, next time around, if she gets another job, provide him proof within 10 days of what her income is. The parties will modify child support based upon the defendant's income. If the defendant fails to find employment by May 1st, and the same thing, if she finds employment by May 1st and then she loses that job or gets another job, we're going to impute income of $20,000 per year, and child support will be calculated accordingly. Child support is payable until the minor child is 18, so the statutory language, until the child graduates high school or emancipates prior to that. The parties will alternate taking the tax deduction for the minor child beginning in every year with 2017. For the tax year 2016, the defendant is going to compute what she would have received had she had the minor child as a tax deduction. And if she were to realize less than plaintiff, then plaintiff will take the tax deduction and pay her the difference. In all future years, the parties are going to just alternate the tax deduction. The parties are going to split equally all public school fees and all mutually agreed upon extracurricular activities for the minor child. Neither parent will unreasonably withhold their consent to avoid paying for their share of the child's extracurricular activities. The parent who paid for the extracurricular activity will be reimbursed by the other parent within 30 days of a written request for reimbursement with accompanying receipt and proof of payment. Currently, the minor child is on Medicaid. Mom will notify dad when minor child is no longer on Medicaid, and then the parties are going to mutually agree on insurance, and the parties will share 50% of any premiums, deductibles, and unreimbursed medical expenses. So what we're contemplating here is if mom gets employment that provides insurance, and that's cheaper than they can get on the market, that they'll go with mom's insurance and split that cost.
For a comparable policy.
Yeah, for a comparable policy. Yeah, we don't want something terrible. It's further agreed by the parties that when it comes to the health care expenses, they're going to have the typical 30-30 rule. They're going to mitigate their health care costs so by trying to use people that are under their insurance all times. And they have lots of standard language, which we've agreed upon, basically saying this is how the mechanism is going to work for the sharing the 30-30 rule. The parties further agree that they shall provide reasonable advance notice by cellular or telephone to the other parent if they are taking the minor child to a doctor for a sick visit, whether that visit is at a pediatrician's office, urgent care, or an emergency room, so as to allow the other parent to participate in those visits. The parties shall schedule any doctor's appointments for well visits in a fashion that allows both parties to attend the well visit together. Neither party shall take the child to a well visit alone. Appointments may only be canceled by prior mutual written agreement, and by written we mean they're going to be on talking parents, so they're going to provide each other written notice that way. Each parent shall provide the other parent the name, address, and telephone number of any babysitter they currently use for the minor child. This is for informational purposes only and doesn't give the other parent a right to veto that caregiver. This information will be only provided once and only updated thereafter should the information change. The defendant will move out of the residence located at 56 Brown Swallow Way, Henderson, Nevada. On or before April 30th, 2017, she will leave the residence in broom-clean condition and not damaged. She does need to paint the residence where the baby colored on the wall. If she doesn't do that, then any security deposit that's withheld for that damage alone would be her responsibility to pay. Otherwise, my client will pick up whatever the rest of it is. If the defendant fails to leave the residence by April 30th, 2017, she's responsible for 100% of the attorney's fees and costs for eviction proceedings that my client may incur, and she's responsible for 100% of the rent for the period that she's holding over. The defendant shall remove her items from the storage unit that my client is currently paying for on or before April 30th, 2017. If she fails to remove her items from storage, she's aware that he's no longer paying, that the same may be confiscated by the rental facility. That the defendant abandons her request to relocate out of the state of Nevada that's currently before Your Honor. As a condition of this settlement, defendant may not file a request to relocate out of Clark County, Nevada with the minor child until the minor child is 6 years old or older, although it is the desire of the parties that they continue to have a joint physical custody arrangement in the minor child's best interest for the foreseeable future, and plaintiff reserves the right to contest any future relocation requests made by the defendant. The minor child shall begin attending preschool the fall after the minor child's 3rd birthday. The parties shall share equally the cost of any mutually agreed upon daycare or preschool. The parties further stipulate that if my client continues to have the minor child 4 days during the week, which is currently his schedule, which is running from Sunday to Thursday, that the minor child will attend school in the school district where he's zoned for. The parties on the holiday schedule, and this might be easier just to give Your Honor and the clerk a copy of it because it's not marked up. So if I can just do that, that might be...
I don't think we need to go through every single holiday.
Yeah, that would be
that's laid
very
out, right?
tiring. So let me give you those pages, Madam Clerk. I would have given you the whole thing, but we had enough interlineations that it just didn't make sense to...
Well, are you going to submit a
Oh, yeah.
an order later, or do you have one ready for my...
Well, it's got a bunch of interlineations in it.
As
So.
far as, before we get further on, unless you want me, so on the preschool, it's basically if they mutually agree, and if they don't agree and he still wants to put the child in preschool during his time, then he's responsible for the cost.
Yeah, it's mutually agreed upon, then they share the cost.
Right.
I want you to add a provision.
Oh, okay. May I have the pen?
Should the parties feel the need to come back to court, in addition to the mediation obligation, there will also be the cooperative parenting obligation. I'll have to go to cooperative parenting.
Take a COPE class again. Okay.
No,
No, UNLV
the
co-parenting?
UNLV cooperative parenting.
Gotcha. Okay.
Have they both attended the COPE class?
Did you take COPE? Yeah, he took COPE.
Okay. Well, this will,
She did.
let's
Okay.
do the, consider this that nipping the problem in the bud.
Okay.
Right.
Okay, take co-parenting class at UNLV if either party wants to come back to court for any reason, or for the relocation, or for what? Oh, I'm sorry. My question was, do they have to take the co-parenting class through UNLV to come back for any reason, or only for certain specific reasons?
If there's a custodial dispute.
A custodial dispute. Okay.
I mean,
I'm
so
sure
if it's for
dispute.
child support, they don't have to necessarily, if there's a child support change, they don't have to necessarily take the co-parenting class.
No, for child support, no. But, for example, anything relating to timeshare and cooperative parenting, they're going to attend the class first.
Okay. Okay. You need a pen? You can't have my pen.
There's a preliminary injunction in a civil case against my client, and my client's agreeing that case will be closed with basically a permanent injunction along the lines of the preliminary injunction.
Right, and that will continue until, we didn't want to say perpetuity because then we may run into problems, so we just said until the plaintiff's death. So that's case number A16748279-C in district court, and what counsel stated was correct, that they have a preliminary injunction currently, and that will continue until...
And that stipulation is going to be filed in that case?
It's going to be filed in that case, Your Honor, and they're obligated to do so within 30 days of entry of this custody decree.
Fine.
That the plaintiff will be allowed to Skype or FaceTime with the minor child every other day when he's out of state for bridge tournaments. Each party is going to bear their own cost and attorney's fees. And my client is going to be able to retain the minor child until March 10th to make up for the 4 of the 7 days he missed during the CPS investigation. And then he will be able to keep the minor child and 3 extra Fridays in May 2017 to make up for the additional time.
Till Friday. So Sunday to Friday instead of Sunday to Thursday.
Correct. Yeah, so he'll have Friday from till 7 o'clock instead of Thursday
Correct.
till 7 o'clock for 3 weeks in a row starting in May of 2017.
There's just one clarification with regard to the bridge tournaments. Because they intend to get as close to a 50-50 timeshare that they can, 7 times a year, she will be guaranteed that Sunday to Thursday time that would be his. because he's getting that extra
That's fine.
overnight 7 times a year. So if it ends up where he doesn't take 7 bridge tournaments, she still gets 7 blocks from Sunday to Thursday of his time to make up for the 1 extra overnight he's getting during the other 3 weeks of the month
That's
or
fine.
so. I just want to make that very clear.
Yeah, no, that's how it's written. So
Sort
that's
of.
fine. That's fine. And he'll give her notice of when he's taking the bridge tournaments, although,
How much notice does she want?
I don't know, 2 weeks, good enough for
You
the...
probably know well in advance when the tournaments are, right?
Yeah, so at least 2 weeks.
Sometimes it comes up at the last minute.
Do they some?
So,
Okay.
well, whatever notice you want is fine.
2 weeks is okay? 2 weeks is okay.
All right, 2 weeks' notice. Okay, we didn't have that in there. I think that's it, Your Honor. Each party's bearing their own costs and attorney's fees, and I hope to clean this up and get it over to Mr. Prokopius' office as soon as I can.
And we should canvass, obviously, the clients.
Yes.
If we can.
We are.
Yeah, this was a lot of work, Judge. I'm not.
And I'm going to make it perfectly clear how impressed I am with counsel. This was not an easy case to resolve, and I think with all of the water under that bridge, the fact that you were able to come together and assist your clients with this is nothing short of admirable. Why don't you canvass your client?
Alrighty.
I'm happy to
Your Honor, I don't know
canvass.
if I got to this or not. I think I did, but as a condition of the settlement, yes, I did. That she's not going to renew a motion until the child is age 6.
Yeah, we did it.
Yeah.
We went
Okay.
over that.
All right. Alrighty.
To relocate.
I don't think you stated that. Her and her parents.
The only thing that my client wanted to clarify is that on that case number, that civil case, that it's going to be her and her parents that are both executing that continuation of the joint
They're
preliminary
both on
injunction.
the situation.
Okay.
We talked about doing some sort of language in this order, saying that
I don't really have the authority to
over
do
the
that.
parents, yeah.
Yeah, that was our concern. Okay. Alrighty. All right. So in canvassing my client, can you please state your name for the record?
Joshua Don.
Alrighty. And you've heard the terms as they were put on the record and read into the record, is that correct?
Yes.
Alrighty. And you've had an opportunity to discuss the terms with counsel and you understand the terms as they've been presented?
Yes.
All right. And you further had an opportunity to review the holiday schedule, which was submitted as an exhibit, and I guess we can make it Exhibit 1, Your Honor? Is
Yeah,
that
that's
okay?
fine.
All right. I'm going to incorporate that language into the stipulation and order, but at least it would be on the court's record as Exhibit 1. And you've had a chance to look through Exhibit 1, which was submitted to the court clerk.
Yes.
All righty. And you understand the terms as they were presented?
Yes.
All righty. And you understand that you and she are going to share joint legal, joint physical custody?
Yes.
And you further understand that you, as Mr. Prokopi has clarified, that you'll be going on 7 bridge tournaments per year, and that she's guaranteed. Pardon?
Guaranteed 7.
That's
It
what I just
could be
said.
more, or
I was
more.
getting there.
Okay.
And that during those 7 weeks, that even if you were available, that those 7 bridge tournaments, Monday through Thursday, will be going to her time-wise, so that you and she share equal number of days.
Sunday to Thursday.
I'm sorry, Sunday to Thursday.
Yes.
So you share an equal number
I
of days.
understand what it is.
Okay. All righty. And you further understand the remainder of it, which was that there's going to be an exchange at Target, that you're going to use proxies that are known to both parties, that the right of first refusal cannot be used against either party in a motion for change of custody, that child support is going to be based upon Wright v. Osborne, and that the medical insurance is going to be either hers or yours, whichever is the best insurance for the least price possible, and that you're going to share expenses 50-50 as far as medical expenses, that she is going to get out of the residence. She's going to be responsible for painting any damage. She's going to leave it broom clean condition and not damaged, and that any security deposit would go back to you, with the exception of whatever the landlord takes, or if she doesn't paint, she'll pay you back for the damage.
Yes.
You understand all that? Okay. I know that was a lot of things. You and she are both going to communicate with each other as far as any doctor visits, and you're both going to make sure that each of you can attend. So if you take the child to an urgent care, ER, or a pediatrician, you're going to notify her ahead of time, whether it's a well visit or a sick visit, and she's going to do likewise with you.
Yes.
Okay. And neither of you are going to cancel an appointment that's made previously as a well visit unless you each mutually agree in writing. Do you understand that as well?
Yes.
Alrighty. And you can provide the names of your babysitters. She's going to provide the names of her babysitters. That's going to be informational only. You can't veto each other's caregivers, and that's to be updated if there's any change in information. You understand that as well?
Yes.
Okay. And you understand that the minor child can attend preschool, and both of you agreed you want that to happen in the fall of the child's third birthday, and that if you mutually agree on a daycare, that you're going to split the cost. Mr. Procopius pointed out that on your 4 days, if you want to send the child to daycare and she's not agreed to that preschool, that you're going to pay the cost. Likewise, if she chooses her 3 days to put the child in preschool, she'll pay for those 3 days. Do you understand that?
If this is what you said, I understand that if we can't agree on a preschool together,
right.
we can each pay for whatever one we want on our own days.
Right.
Yes.
You understand that? Okay. All right. And you further understand that the judge added that if there is any type of timeshare dispute or co-parenting, cooperative parenting dispute, custodial dispute, that the two of you are going to take the co-parenting class at UNLV, which I believe is a 6-week course, right? Is that a 6-week course?
It's 8.
8? Okay, 8-week course, which is an 8-week course, and you're going to attempt mediation and or agreement prior to bringing back a motion before the court.
Yeah, we have to take the class if we go back to court.
Before
going to court.
Yeah,
We must do
Your
it
Honor,
before.
it was before court, correct, Your Honor? Before the filing of the motion, actually, correct?
Okay.
Okay. Yeah, before the filing of the motion, you would have to take cooperative parenting. It doesn't apply to financial issues. It applies to co-parenting and custodial disputes.
Okay, I understand.
Okay. Alrighty, and the vacation time we talked about, the civil case we talked about, which is that your counsel in the civil case is going to prepare a continuation of the current preliminary injunction, and the defendant's parents and the defendant will be signing that, and then in return you will close that case. You understand that as well?
Yes.
Alrighty. And you further understand that you're allowed Skype or FaceTime every other day while you're gone on a bridge tournament, and that each party is going to bear their own attorney's fees and costs?
Yes.
All right. I think that is it, Your Honor, unless either...
I just want to ask him a couple clarifying
Yeah.
questions. First of all, Your Honor, with regard to the co-parenting course, the person that wants to move the court has to take that first. So it's not like if my client took it...
And that assumes there's no emergency, and I want to make it clear.
Right.
If there's an absolute real emergency, but if the other party wants to oppose, they will at least have to have signed up for the class.
So that's what I was concerned about is she takes the course, she files a motion, he just never goes and takes the course, and then she can't file her motion, and I don't...
So whoever files the motion has to at least be enrolled in the course and attending. If the other party wants to oppose, they're going to have to attend as well.
Okay. And then I just want to clarify with you, sir, seven bridge tournaments are guaranteed to my client. You understand that? So
Yes.
Even if you don't go 7 times, she gets your Sunday to Thursday 7 times a year.
Yeah, if I've gone 6 times for the year, and I don't have any more, I'll give her some week in December.
And also, if there are more bridge tournaments, she gets the child for those bridge tournaments too.
Yeah, my understanding is if there's more, there's 7 times I'm guaranteeing her Sunday through Thursday.
Right.
If there's an 8th and I'm going to be here on Monday and leave on Tuesday, I can still have that Monday because
Right.
I've given her the 7.
But she gets the child if you're gone.
Yes.
For the bridge tournament.
Yes.
More than 6
It
hours
just
on
might
a
not be the full 4 days beyond the 7th.
Yeah, that's fine.
Okay.
That's what I just want to make sure it's clear. So it's not like 7 times and then you go to an 8th tournament for a week and you say, I don't have to give
No,
my
I
time
understand.
there. Okay. And that's all I have for him, Your Honor.
Sir, are you entering into this voluntarily?
Yes.
Has anybody made any promises or threats to cause you to consent?
No.
Are you under the influence of any substance which would affect your ability to consent?
No.
Okay, Mr. Procopius, you're on.
State your name.
Amanda Mitchell.
Amanda, you heard the representations made on the record with regard to settlement in this matter, correct?
Correct.
And we've gone through a lot of time together, correct?
Correct.
And we've done a lot I've done a lot of counseling back and forth with you. We've gone through every fact, every scenario in this case, correct?
Correct.
And at this time, due to the possibility of different outcomes of this court, et cetera, you believe that this is a fair and equitable resolution to this case, correct?
That is correct.
And at this time, because of the possibilities of different outcomes, this is in the best interest of your child?
Correct.
And nobody's forcing you into ending this negotiation date, correct?
Correct.
I haven't twisted your arm. I haven't threatened you. Nobody's forced you to do that, correct?
Correct.
You're doing so on your own free will.
Correct.
We've submitted, Judge.
Do you have any questions?
I do not, Your Honor. Thank you.
And for the record, ma'am, you're not under the influence of any substance which would affect your ability to consent?
Correct.
All right. In light of this testimony and the record before me, and again, my great admiration for the efforts of counsel. I'm accepting this, and I gather I should be getting a stipulation within the week.
Yes, Your Honor.
Correct.
Okay, thanks.
Thank
Now
you, Your
can
Honor.
go to
Thank you.
Bishop.
Appreciate it.